Good afternoon. My name is Dr. Xolisile Khanyile. I am from the University of Zululand in South Africa. My title for my article is the impact of compromised chain of custody in the admissibility of evidence in South African criminal trials. Introduction. It is submitted that a chain of custody ensures the evidence remains authentic, untainted, and admissible in a South African criminal trial. This is governed by legal frameworks including the Criminal Procedure Act, the RITA Act of November of 2022, and it is protected under the Constitution, and this is also protected under Section 35 of the Constitution of South Africa. It is further submitted that a compromised chain of custody may lead to evidence being excluded, or it may also lead to risk of wrongful conviction or even acquittal. This paper physically explores a practical sequence where such breaches through statute, case law, and procedural analysis. It concludes with a recommendation to strengthen procedural safeguards and to uphold justice and system credibility. What is my research problem? It is submitted that in South African criminal trials, the integrity and admissibility of evidence are essential to uphold the accused constitutional rights of the trial, as entrenched in Section 35 of the Constitution. A fundamental mechanism for preserving evidentiary integrity is the chain of custody, which ensures that the evidence remains untainted, properly documented, reliable when presented to court. However, in practice, breaches in chain of custody, whether by poor handling, inadequate documentation, or procedural lapses, pose serious challenges to the administration of justice. Despite the existence of multiple legal frameworks such as the Criminal Procedure Act, the ICSD Act, and RITA, there is limited scholarly focus on how South African courts can apply these standards when determining admissibility of evidence that has been mishandled or inadequately traced. This creates a legal procedural gap that may result to people being acquitted in crimes like rape, or people just being convicted for crimes that they didn't commit. And eventually, it ends up undermining the public trust in the criminal justice system. Therefore, it's a critical examination of the legal implications and practical challenges of compromised chain of custody. It's both necessary and urgent. What are my research questions? Number one, what are the legal implications? What are the legal principles and critical frameworks that govern the chain of custody and the admissibility of evidence in South African criminal trials? How has South African courts interpreted the applied requirement of continuous chain of custody in case law where the integrity of the evidence has been disputed? What are the critical challenges faced by law enforcement, forensic experts, and legal practitioners in maintaining a secure chain of custody, particularly handling of physical and digital evidence? What is the legal framework that encompasses or rather governs the chain of custody in South Africa? South African common law underpins admissibility of evidence and emphasizes on integrity, reliability, the burden of proof, and the prosecution. A properly maintained chain of custody proves that evidence is untainted, supporting its authenticity and admissibility. Following other case laws that have dealt with chain of custody. For instance, State versus Maluka, State versus Zulu, court excluded or questioned the evidence due to the broken chain of custody. On the same thread, in State versus Dogo, the court held that the gaps in the chain required explanation to ensure fairness and avoid prejudicing the accused. However, even though the case of Dogo does bring a sort of like a remedy to say that maybe during the from the crime scene and transporting the evidence and putting it in the police station and documenting it all the way up until it gets to the lab. What is then that chain gets broken? Given that in South Africa, already our courts have a backlog, you may find that the people that maybe were even handling the evidence, if maybe the chain has been broken, when you do seek for things that actually did test the evidence, you may find that maybe they are confused because sometimes some cases take very long, especially when where they have to go to the lab or it's very quick, it's blood samples, they do take some time. These cases actually do highlight the role of common law in safeguarding fair trials and rights to strict adherence to evidentiary procedures. Criminal Procedure Act. The Criminal Procedure Act governs criminal trials and implicitly supports the legal significance of chain of custody. Section 210 requires that the evidence must be relevant, reliable, which includes proper handling and preservation. Section 37 authorizes evidence collection. For an example, clinically, blood samples, blood spatter, it imposes a duty to maintain its integrity, as supported as the case of State versus Ramkopini. The court stressed that real evidence must remain substantially the same condition as when it was first obtained. Together with Section 210, Section 37 of the Criminal Procedure Act emphasizes on the procedure of fairness and justify excluding of evidence compromised by the broken chain of custody. What if this is a murder case? What if this is a rape case? And then you cannot link the accused through DNA. Then there is when now the integrity of the evidence is of very high paramount because if the chain gets broken, chances are accused that are guilty of the crime are likely to escape punishment in this regard. And on the third word, there's an Electronic Communications and Transaction Act. It stipulates that this act basically governs the admissibility and availability of electronic evidence. We are in a very, as we stand right now, we're in a very critical era where a lot of crimes are committed digitally. One of the days where everything has to be documented, but most of the crimes now are committed online. WhatsApp messaging. So basically, this act governs on how the SAPS, which is the South African Police Service, are supposed to handle such evidence. And this act has become very important given that technology is moving on a very high pace. So it is submitted that in Section 14 and 15, it emphasizes the evidentiary weight of the digital data, and it depends how it was generated, how it was stored, and how it was preserved. Proper digital chain of custody is basically required to prevent tampering, deletion, unauthorized access of electronic evidence. This was supported by a case of State versus Ndidi, where the court questioned the availability of digital evidence that made safeguarding, showing the need for its handling. And this is very imperative to take anything digital with AI, anything can be tampered with. So with that being said, the ECCA basically aligns as well with Section 35 of the Constitution, which is the right to fair trial, the right to remain silent, and it does reinforce those rights simultaneously. Failing to comply with the ECCA Act permits evidence being excluded and may compromise the prosecution's case and public trust in the justice system. On the same verse, there is an act called Regulation Intersection of Communication and Provisions Communication-Related Information Act, known as RICA. It basically governs the lawful interception and handling of communication-related data, balancing the law enforcement needs to privacy rights. Intercepted evidence must follow a documented chain of custody to ensure it's lawfully obtained, secure, and untainted. Section 16 and Section 22 requires digital authorization of interception, which failure to comply risks an for it to not be admissible in court under Section 25 of Section 5, again, which is the right to a fair trial. No court in their right mind will accept evidence as admissible if such evidence has been tampered with. Specifically, where maybe the South African Police Service had to intercept the communication to get relevant evidence. The prosecutor still has to come and prove the chain of evidence that it was never tampered with for it to be admissible as evidence. This also speaks to the case of Minister of Safety and Security Khanyile. The Constitutional Court emphasizes strict adherence to the procedural safeguards, given digital formats and multi-party handling. Logging and method data are essential to maintain the productive value. This reinforces that intercepted evidence must be obtained lawfully and handled transparently to meet the admissibility and the constitutional standards. Judicial precedent. In the absence of codified chain of custody rules, the African courts rely on case law to uphold the evidentiary integrity. Cases like State versus Namibia, State versus Zululand, highlight the failure to maintain a clear custody trail and familiar evidence in admissible in court. This is normal and technical Ramsey affirm that minor defects do not automatically exclude the evidence if reliability is not materially affected. Courts can apply their own discretion in evaluating the totality and circumstances and any potential prejudice to the accused, even though the state is given this leeway. However, if the accused person is being defended by an attorney that is going to fight tooth and nail for the evidence not to be administered because the chain broke, then it is very imperative that the prosecutor, when they do present the evidence, it must be watertight. Physical evidence as soon as it is being used requires a high safeguard due to availability, surveillance, judicial discretion, guided by Section 35 of the Constitution, ensures fairness, protection against a right violation. So, further to this, now we have to look at the South African Police Standards operation. So, the South African Police Service Standard of Operation Procedures has developed under cybercrime a guide of how to properly handle electronic or physical evidence. The standard operating procedures basically ensures a verifiable chain of custody through a detailed record, trained personnel, and secure packaging and storage. The standard operating procedures emphasizes the data integrity, audit trails, constitutional compliance, especially under Section 25 of 55. Any procedural lapse, such as mishandling, undocumented transfer, can compromise the evidence and it sends a risk for the court not to admit it as evidence. In a nutshell, the South African Police Service Standard of Operating Procedures is crucial for preventing evidentiary variance, ensuring a fair trial, and maintaining public trust in law enforcement. In conclusion, a thorough training of custody undermines the integrity, reliability, admissibility of evidence in criminal proceedings. The African court requires strict compliance with evidentiary standards to ensure fairness and to uphold constitutional rights. The South African Police Service Standard Operating Procedures play a vital role in maintaining evidentiary trials, particularly in cybercrime and digital evidence cases. Judicial scrutiny, irregularities in handling, can lead to exclusion of crucial exhibits, potentially leading to acquittal. Thirdly, training, oversight, and to adhere to South African operating procedures is essential to safeguard justice and public trust in the criminal justice